Hi, I'm Stacey and I'm joined here today by my colleague Robert. We are assistant managers within the AML CFT division at the Isle of Man Financial Services Authority. We would like to take the time to thank you for viewing the webinar in relation to the DNFBP update. As part of the webinar's news release, we asked the designated businesses to submit any questions they would like answering in order to shape the form of the webinar. Any questions that we did receive will be answered throughout the presentation where possible or at the end. We hope you find the webinar useful, and if you have any feedback, it can be sent to the DNFBP mailbox and the email address will be listed on the final slide of the presentation. I will now hand over to Robert, who will take us through the agenda.
So we're going to be taking you through the agenda today. I'll be covering some particular topics which are set out on the slide. However, we do only have half an hour, so what we will discuss today will be at a very high level. Apologies for the level of information on the slides, but we wanted them to be a useful document to refer back to. We are aware some part of industry have already received outreach for their specific activities, and a lot of information contained within these slides will seem familiar. There is, however, a number of items being touched on that may not have been covered. We would request that you stay tuned for the entire webinar, as it may add additional insight to your understanding so far. Should the webinar raise any further questions for you, please contact us using the contact information at the end of the slides. We will be providing a relevant link at the end, such as the AML CFT Statistical Return webinar, access to the updated return form, and any guidance. So we'll start off with the designated business activities. According to Schedule 4 of Proceeds of Crime Act 2008, this highlights the business activities considered to form part of the regulated sector, therefore are subject to the AML CFT code. Schedule 1 of the DBRO Act 2015 highlights the activities that can be carried out by designated non-financial businesses and professions. It is useful to note that DNFBPs do not require a license in order to operate, however, they must be registered under the DBRO Act 2015. The list goes as follows: legal professional, an external accountant, a tax advisor, a payroll agent, a business which provides lending, a business which provides financial leasing agreements, a business which provides financial guarantees and commitments, an estate agent, a business which deals in goods and services accepting total cash of 15,000 euros or currency equivalent, a business that provides safe custody facilities, a business engaged in CVC activities. CVC is convertible virtual currency. A specific a specified non-profit organisation. I'd like to touch back onto one of these points. A business which deals in goods and services accepting physical cash of 15,000 euros or currency equivalent is meant. So the highlight is on physical cash. Full definitions of each business activity detailed in Schedule 1 is detailed in Schedule 1 of the DBRO Act 2015. Now I would like to touch on the Designated Business Registration Oversight Act 2015. This was brought into effect in 2015. The purpose of such is to ensure the AML CFT oversight for businesses that fall outside of the licensing requirements under the Financial Services Act 2008. Oversight provider can either be the authority or a delegated body, touched on in more detail later on in the slides, and the preference of which is determined by the designated business. It is impossible to capture all activities within the DBRO Act, as there are a large range of scenarios. Please be sure to refer to your sector guidance regularly, which provides more bespoke information.
So now we're going to look at changes to the DBRO Act and any ongoing obligations. To clarify, the DBRO applies to designated businesses and sets out the authority's powers in relation to oversight and the firm's requirements regarding registration and its ongoing responsibilities. A key change to highlight is that the annual return has merged with the AML CFT statistical return. The merge was communicated via press release on the 15th of February this year. The reason for the merge is the authority are moving to one return in order to gain a consistent picture of risk and to conduct efficient financial crime risk assessments. The benefit to firms is that this means there is only one return to be submitted moving forward, and there is a longer period for completion and submission. A webinar has also been uploaded to our website. Please watch and refer to us with any questions, and we would appreciate the returns being submitted by the 30th of June. A further change to refer to is the amendment bill. The amendment bill is currently underway and we expect it to be implemented by the end of 2023. What this means is that the authority will have the ability to issue a civil penalty for not advising the authority of any material changes to a DNFBP registration within the required 14 days. Moving on to the ongoing obligations, we'll start with changes to be notified to the authority, as this goes hand in hand with the amendment bill I've just referred to. The authority should be notified of any changes to DNFBP registrations, including changes to personnel, registered and trading office addresses, a change in activities, a change in percentage shareholding or control percentage, a change of oversight body. All of these changes will need to be notified to the authority, and a new business details form will need to be submitted via the portal. If the changes relate to key personnel within the business, a specified persons questionnaire may be required. Further ongoing obligations are: we would appreciate that you respond to requests for information in a timely and effective manner. This is in relation to requests from both the authority and any professional bodies. Ensure compliance with any direction or condition applied to your registration. A direction or a condition will not be applied without prior notice. And as previously highlighted, please ensure that you make us aware of any changes to your registration.
In this slide, we will be touching on the points raised as a result in failing to comply with the code. There are both civil and criminal penalties available in respect of contravention of the code. Typically, in most cases, the authority would seek to use civil sanctions available, but in cases with extremely serious failures, it may be appropriate to pursue criminal sanctions. The civil penalties guidance is on our website. This is a fairly new tool named Anti-Money Laundering and Countering the Financing of Terrorism Civil Penalties Regulations 2019. A link to the guidance document can be found on the links and contacts slide of this presentation. Any civil penalty imposed on a firm will be issued in line with EDMP. This is Enforcement Decision Making Process. This is also publicly available on our website. There is a possibility that the authority directs the appointment of a third party in relation to any remedial action required. Enhanced supervision. The supervisory powers are delegated to the professional bodies, whom in turn supervise their members. They also deal with any non-compliance and remediation aspects. However, in serious cases, the professional body and the authority may agree to enforcement consideration by the authority. The deed of authorizations state the professional body may inspect or investigate. We have the right, but not the obligation, to resume oversight for a firm from a professional body. If we decide to take enforcement action, or we decide to take supervision away from the professional body and supervise the firm ourselves. Remediation. Firms should work alongside the professional bodies and or the regulator in terms of remediation to ensure compliance moving forward. Utilise powers of DBRO15. Failure to comply with the DBRO will be touched on in the next slide. Okay, moving on to failure to comply with the DBRO Act 2015. Civil penalties. Examples of situations whereby a civil penalty may be imposed are failing to submit an annual return or failing to pay the annual fee, holding out, carrying on without being registered. By this we mean to provide or advertise as offering certain services without first being registered with the authority, as per Section 7 of the Act. To name a few of them, along the lines of the ones stated, we'll start with directions. This is when the authority mandates you to comply with a particular requirement specific to the business in which the direction is applied to. An example mandating specific training is undertaken in a time period, or a compliance professional is appointed to review policies and procedures. Conditions. These are public and can be applied at registration. For example, CVC Business have a condition applied whereby they must have 2 Isle of Man based directors at all times and must be able to evidence that the management and control of the business is undertaken in the Isle of Man. Injunctions. To prevent, compel certain actions being conducted. An example, shutting down a website that was advertising regulated registrable activities without being appropriately licensed or registered. Revocation. Removal of registration can no longer undertake designated business activities. Public statements will be issued on the Isle of Man Financial Services Authority website if deemed to be in public interest or to their benefit. In this slide, we will be touching on delegated functions. The DBRO Act 2015 allows the authority to delegate certain aspects of the authority's function in relation to AML/CFT oversight. If you are a member of a professional body, you may have elected to be overseen for AML/CFT compliance by the relevant professional body. This slide sets out some of the key responsibilities of each party. Professional bodies are delegated to be the supervisor under the Act and are considered as the AML/CFT supervisor in their own right. In certain instances, the authority may deem it necessary to conduct its own inspection. For example, a thematic project, or possibly an instance where there have been repeated or significant contraventions. Further, we may conduct a quality assurance exercise to any professional body we delegate to. Also note that all inspection reports are provided to the authority following an inspection and notify the authority of any adverse media or matters they have observed. Where a professional body has been delegated to oversee a firm, the authority will remain responsible for all other powers outlined in the DBRO Act 2015, and a link to this document will be provided on the slides towards the end. The authority also provides training and guidance to the Isle of Man Law Society where it is deemed necessary. The authority retains the majority of functions, responsibilities, such as enforcement action.
Going back to the code, we wanted to take the opportunity to highlight some of the key considerations that DNFBP businesses should take into account. The code sets out preventative measures in which firms are required to comply with. The measures are in line with international standards and ensure businesses have the appropriate procedures and controls in place to protect itself and its customers from being exposed to MLFT risks. The code requires relevant persons to undertake a BRA and a TRA, that's a business risk assessment and a technology risk assessment, as soon as practicable after the relevant person commences business. The risk assessments must be recorded in order to demonstrate their basis and regularly reviewed. The code further requires a CRA, that's a customer risk assessment, must be undertaken prior to the establishment of a customer relationship or occasional transaction. Again, the risk assessment must be recorded in order to demonstrate its basis and regularly reviewed. The code also has requirements in relation to the level of CDD and whether ECDD requirements should be applied, and these should be considered in full by the relevant person. CDD includes but is not limited to the identification and verification of a customer's identity, understanding the nature and purpose of the business relationship in which it is entering into, and source of funds. Ongoing monitoring. A relevant person is required to perform ongoing and effective monitoring of any business relationship or occasional transaction, including scrutiny of transactions, review of information and documentation held for the purpose of CDD, ECDD, the BRA, CRA, and TRA, and the relevant person's knowledge of the customer. The relevant person should ensure a record-keeping policy is in place and clearly documented as per paragraph 33 of the code. Further, the relevant person should establish, record, maintain, and operate reporting procedures and controls that enable it to effectively meet its reporting requirements. We wanted to also touch upon the concessions and simplified measures that can be utilised across the sector. We haven't set out the concessions in full, we just wanted to highlight the concessions that could be utilised. In any instance you are unsure of the right path to choose, we always recommend that you refer back to the code and your sector guidance. Generic designated business is the main concession utilised by DNFBPs and is typically only available to accountants and tax advisors in certain circumstances. The GDB concession means that if all elements of paragraph 18 of the code are met, then verification of identity of a customer is not required for a new business relationship or an occasional transaction. Acceptable applicants is another concession that is available to use. Acceptable applicants is referred to in paragraph 16 of the code. You can only utilise this concession where the acceptable applicant is your customer. There are specific conditions to be met in order to apply the acceptable applicant concession, including the customer must be acting on their own behalf and must not represent a higher level of MLFT risk. There are other concessions in the code, for example, the eligible introducer concession, this is paragraph 19, which can be viewed in full within the code and are explained further in the AML handbook and sector guidance.
I will now be touching on the fitness and propriety under the DBRO Act 2015. Under section 9.4 of the DBRO Act 2015, it highlights what might constitute a person to be deemed not fit and proper if they have been convicted of an offence under AML CFT legislation, under the law of a country or territory outside the island, if the conduct gives rise to the offence and would constitute an offence under subparagraph I, if that had occurred on the island, involving dishonesty, whether under the law of the island or elsewhere, under a relevant act, or a perjury or conspiracy to pervert the course of justice, whether under the law of the island or elsewhere. Furthermore, A person may not be deemed fit and proper if they have been the subject of any action with respect to any breach of a relevant Act or AML-CFT legislation, have knowledge or recklessly provided misleading or false information in the application for registration, or is otherwise considered by the authority not to be fit and proper for reasons related to the risk of money laundering and the financing of terrorism.
We are aware you'll have recently seen the press release about the new supervisory structure and approach. We have also recently published a document and a webinar in relation to the new methodology. We wanted to touch on this because whilst it won't have a huge impact in relation to DNFBPs, we are aware that the news is out there and you may have some curiosity. For DNFBPs, this doesn't have a great deal of impact as the DNFBP sector is only overseen by the authority for AML-CFT compliance purposes, and so the responsibility for that remains with the AML-CFT Supervision Division. One change that may be noted by the DNFBP sector is that new registrations and amendments to registrations will now be dealt with by the authorisation team as part of portfolio supervision with effect from the 1st of April. This was previously undertaken by the AML-CFT Supervision Division. Firms will continue to be risk assessed by the authority based on data collected, and this will have an impact on the supervisory approach applied. We are operating 4 risk ratings, which Rob will now touch on.
I'm going to run through the risk ratings briefly. We just wanted to touch on the risk rating as per the new supervisory structure. So I'll be touching on the residual risks of each one. So high risk, residual risk. There is an imminent risk or significant harm or loss to consumers or MLTF threat occurring without critical and immediate corrective action being taken. Medium high risk, the residual risk. There is a risk or significant harm or loss to consumers or MLTF threat occurring without corrective action being taken. Medium low risk, residual risk. There is a low to moderate risk of significant harm or loss to consumers or MLTF threat occurring. And then finally, low risk, residual risk. There is a minimum risk of significant harm or loss to consumers or MLTF threat occurring. I'll now touch on the supervisory activities. Again, this is a very high level, but we wanted to highlight some of the supervisory activities undertaken by the authority. I'll do them in order. Inspections. These can be full or thematic based, on-site or desk based. Meetings. Business meetings preferably undertaken face-to-face at the authority's office, but alternatives can be arranged if required. Returns. AML, CFT statistical return, and any other ad hoc return that may be required. Risk assessments. As per the previous risk rating, the authority will be risk assessing the firms registered or licensed with us. This will steer the risk-based approach as to how and what level of supervision is required. Stakeholder engagement. The authority will be focused on outreach and engagement with licensed and registered firms. Supervisory colleges. This may be held in order to share information between relevant oversight bodies and other regulators. Triggers. These can be changes in activity, changes in or entry into an additional sector, change in directors, controllers, and please be aware that this list is non-exhaustive.
As referred to numerous times within the presentation, we thought it would be useful to end on a slide containing key contact information and links to the other webinars we have referred to today. If there are any webinars that we have mentioned and are not listed, please feel free to contact us via the DNFBP mailbox.
We received a number of questions into the DNFBP mailbox following the news release on the 2nd of June 2023. We have tried to incorporate the answers within the presentation, but thought it would also be good to highlight some of the questions submitted. I'll start with the first question. It's from Miss D. At what point can a direction be removed? This is a good question. A direction can be revisited once a designated business has demonstrated they have complied with the requirements. The designated business can submit a request for the direction to be reviewed, at which point the authority may wish to conduct an inspection in order to test the policies and procedures and make an informed decision as to whether the direction can be removed or amended. In addition to the question, this would also be classed as a trigger event in relation to the supervisory activities.
Following that question, we also received a question around when a business can expect an inspection. Inspections are scheduled and undertaken in line with a risk-based approach. That's why completion of the AML CFT statistical return is really important. Firms will be selected based on identified risks or as a result of their overall risk rating. For entities that pose a lower risk of MLFT, the authority may undertake a desk-based inspection, whereas for those that pose a higher risk of MLFT, the inspections would likely be conducted on site. Furthermore, as touched on briefly earlier in the presentation, the authority also has the option to conduct thematic-based inspections, choosing to look at a specific sector or topic.
On behalf of my colleague Stacey and myself, we would like to thank you for taking the time to view and listen to us on this webinar. And if you have any queries, please refer back to the slide which contains contact details. On this slide, you will find a number of links that you can also review at any time. During the review, if you have any questions, please use any of the emails provided, should you need to ask us any questions. Thank you again.
Thank you.